brothers and sisters, friends and enemies. I just can't believe everyone in here is a friend, and I don't want to leave anybody out. The question tonight, as I understand it, is where do we go from here, or what next? In my little humble way of understanding it, it points toward either the ballot or the bullet.
What's up, guys? It's boy Benny. We are all about cutting right to the chase when it comes to complicated legal or constitutional issues. We would prefer to tell you what happened in meme form. And so if you want to know what just happened to the seething lib case trying to strip Donald Trump from the ballot in Colorado, here, ladies and gentlemen, is your meme. They have been officially and thoroughly f***ed over. They have been destroyed in the court of law, the Supreme Court, and we may well see all 9 justices rule against the seething, blue-haired libs of Colorado trying to keep Donald Trump from the ballot, trying to stop all of us from voting for Donald Trump. It's not going to work. And it is unbelievable that some of the justices who were appointed by Joe Biden just moments ago in the court are like, what you talking about, Willis? Like, why? Like, what are you talking about here? The lib petitioner who was sent in there, a guy named Justin Murray, was so thoroughly eviscerated by the court, vaporized by the court, that they'll, quite frankly, be writing about this for many, many generations to come. A wonderful day for the movement for freedom, for constitutionality in America. The arguments just wrapped seconds ago. Supreme Court is primed to keep Trump on Colorado ballot. In blockbuster hearing, liberal justices expressed deep concerns. And his lawyers since January 6th was just a riot and not insurrection because nobody's been charged with insurrection. Not Donald Trump. Not anyone in his cabinet. Not any of the speakers on January 6th. Not anybody who even entered the Capitol on January 6th has been charged with insurrection. None of them. No one. And so now they're trying to keep Donald Trump from the ballot, which was always the goal, in fact, over this arcane rule in our Constitution. It's not going to work, ladies and gentlemen. Donald Trump was declared ineligible to appear on the Colorado ballot on December 19th. The decision marked the first time in history that Section 3 of the 14th Amendment has been used to disqualify a presidential candidate, which, of course, is illegal. Supreme Court justices will hear an argument from both sides over whether Trump will be eligible again. Ladies and gentlemen, the reporting out is that the Supreme Court is poised to reject the effort to disqualify Donald Trump. It's not pretty. A total and complete humiliation, says Julie Kelly about this decision. Julie Kelly saying it's clear that SCOTUS's decision will not even be close and will represent a total humiliation for those legal experts and historians who filed amicus briefs in favor of Colorado's actions. Jonathan Turley, one of our favorite legal experts. The argument is now over. The disqualification advocates may have expected a cold reception, but this was perfectly glacial. Notably, some of the toughest and most skeptical questions came from the left of the court, which is quite interesting. Most notable, there were questions from Justice Jackson, who seemed to push the idea that the president may not have been intended to be one of those covered by the provision, meaning that presidents actually can't be prosecuted under this constitutional clause. Overall takes, based on the oral arguments, highly likely Donald Trump wins going away. At least 6-3, more likely 8-1, possibly 9-0. There's a lib freaking out about this. They may not all agree on the same reason for it, but basically they don't like what Colorado has done. Oh yeah, baby. Look at this. The seething and the crying has now begun on MSNBC. With Mr. Weissman, the Trump-deranged Robert Mueller attack dog, leftist shill, who is not a legal scholar or a legal mind, but is simply a weapon of the Democrat Party to engage in lawfare, literally crying, mewling, and that Donald Trump won this one walking away.
In this process, and that ambiguity would favor keeping the candidate, Donald Trump, on the ballot.
I agree with you. My takeaway from this is you're counting the votes. Remember, Justice O'Connor famously said when she was asked what's it like to be on the Supreme Court, it's about counting to 5. Here, there is clearly, I think, 5 votes, if not 9 votes, that are going to reverse this.
Oh, yeah, baby. 9 votes. It could be unanimous, is what this guy's saying. And that guy has full-blown TDS. Molly Hemingway, who was outside of the court, just left oral arguments. She was inside the court, in fact. Colorado's partisan court attempts to remove a popular Republican candidate from the presidential ballot. Based on the questioning and response legal observers I spoke with, this could be 7-2, 8-1, or 9-0, unanimous. And some of the most Trump-deranged, seething, repulsive, grotesque members of the left, like Lubin Tubin, who's been humiliated, disgraced, and fired from all of his positions for, beating himself up, frankly, about some of the legal issues of the day, has in fact conceded that the argument is going very well for Trump. The justices, including Kagan, are worried about the lack of standards defining and proving insurrection and concerned that states will disqualify candidates for political reasons, obviously, because Trump hasn't been charged with insurrection. Yet not only has Trump not been convicted of insurrection, he hasn't been charged with insurrection, nor has anyone been charged with insurrection for whatever they did on January 6th. Some people did behave criminally on January 6th. Okay? I've said this often. If you punch a cop, if you hit a cop, you should go to jail. Okay? Doesn't matter if you're wearing black bloc or MAGA hat. But those people haven't been, people that actually did behave criminally, didn't get charged with insurrection. Yet they're trying to get Donald Trump off the ballot, which was always the goal of the Fedsurrection. After a sprawling argument that went on nearly twice as long as its allotted time, it's clear that the Supreme Court will leave Donald Trump's fate to the voters, not elected officials, says legal expert Ilya Shapiro. U.S. Supreme Court appears set to strike down Colorado ruling, kicking Trump off the ballot. All of the handicappers in politics are saying this decision's done. This decision's over. Clarence Thomas, to libtard lawyer. This is the guy who is arguing on behalf of Colorado, who just got eviscerated in court. Do you have any historical examples that back up any of your arguments? Stammering, shaky, sputtering out. Clarence, so no examples like this, even from the Civil War. What are the examples? Ooh, baby, you got to hear this one. It's so good. This is where the Crowder Mug Club meme comes from, this exact moment here, with Clarence Thomas asking the questions. Have a listen. You're going to love this. Clarence Thomas on fire.
The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think...
So, ladies and gentlemen, it wasn't just that pistol whipping inside of the court. Brett Kavanaugh went ahead and got out his boofing and devil's lettuce and devil's triangle and whatever else they wrote about in his yearbook, and went to town also on this psychotic, very creepy looking lib petitioner, Colorado's attorney argues Trump is a threat to democracy and voters need to be protected from him. The whole case is that we need to protect voters from the person they want to vote for. Kavanaugh having none of that. If you're convicted of an insurrection, you shall be disqualified from holding office. President Trump has not been charged with an insurrection, says Kavanaugh. Have a listen.
He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, you are, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted.
So going down the right wing of the court, Gorsuch, another Donald Trump pick for the Supreme Court. This is a bloodbath. Gorsuch spends 2 minutes slapping around Colorado's lawyer. Gorsuch is from Colorado. This has got to hurt. You almost feel bad for the guy. Go.
He speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment. Self-executing. Done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is...
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you, I understand. But I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it. Okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules.
So, ladies and gentlemen, it's not even just the right flank of the court. It is also the left flank. Liberal Justice Ketanji Brown Jackson, nominated by Joe Biden, sees how ridiculous the argument is. Donald Trump off the ballots in the 14th Amendment. Ketanji Brown Jackson. I'm saying the language here doesn't seem to include the president. Why is that? Why the ambiguity? Why would we construe that, as Justice Kavanaugh pointed out, against democracy? Trump is staying on the ballot. So Ketanji Brown Jackson can see the absurdity of this case. Ketanji Brown Jackson is destroying Colorado's entire argument. They were listing people who were barred from office under the 14th Amendment, and the president is not on there. Painful and beautiful. Have a listen.
My view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed to focusing on the presidency?
Well, 2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Commentators are saying, here's a clip in which Jason Murray, Colorado, argues that the Supreme Court doesn't remove Donald Trump from the ballot. Democrats will have to try and stop Congress from certifying the electors if he wins. So Democrats will engage in insurrection themselves. Oh, it's too good. Justice Alito questions, who can enforce Section 3 of the 14th Amendment, unintended consequences of the Colorado Supreme Court's decision? Yeah, is it up to the states? Who's the enforcement mechanism here? It doesn't fall to the states. Justice Alito going in. Smart. Go.
I don't see what is gained by using this term, which is used in different contexts, rather than directly addressing what's involved here, which is the question of who can enforce Section 3 with respect to a presidential candidate. The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe. Would it not permit, would it not lead to the possibility that other states would say, using their choice of law rules and their rules on collateral estoppel, that there's non-mutual collateral estoppel against former President Trump? And so the decision of the Colorado Supreme Court could effectively decide this question for many other states, perhaps all other states. Could it not lead to that consequence?
I don't think so, because Colorado law does not recognize non-mutual collateral estoppel, and I believe the preclusive effect of the decision would be determined by Colorado law rather than the law of another state. But I think your question, Justice Alito, gives rise to an even greater concern, because if this decision does not have preclusive effect in other lawsuits, it opens the possibility that a different factual record could be developed in some of the litigation that occurs in other states, and different factual findings could be entered by state trial court judges. They might conclude that, as a matter of fact, that President Trump did not have any intent to engage in incitement, or make some other finding that differs from what this trial court judge found.
Yeah. So everybody is saying the Supreme Court should rule 9-0 against Colorado and Maine, striking Trump from the ballot. The questionings have been a bloodbath for the Colorado and Maine attorneys. They are getting utterly destroyed. Even Elena Kagan, Obama appointee, is now giving the lawyer a hard time. Seems doubtful that it makes any sense that one state can basically make the call for the entire nation. This case is looking to be a 9-0 decision. Correct. Overturning the corrupt Colorado decision is a good starting point. Prosecuting the POSs who tried to take our rights to vote should be next. Yes, remember These absolute goblins. Yeah, you know exactly why these people are voting the way that they voted. You know exactly why. It has nothing to do with the rule of law in this nation. It has absolutely nothing to do with anything other than griping, seething, salty personal animus, because they're not getting their way politically. Even SCOTUS analysts on CBS just said it's likely to be a unanimous decision because the court will want to speak with one voice against opening a Pandora's box of states saying, no, you can't be on the ballot because we don't like you. Amazing. Donald Trump's attorney, by the way, doing a great job. Not enough is said about Donald Trump's attorney. President Trump is not covered by Section 3 because the president is not an officer of the United States. The measure known as Section 3 of the 14th Amendment applies to officers of the United States. That phrase does not include the president. States do not have the power on their own to bar candidates from the ballot based on Section 3. Could a state bar a candidate even if they openly acknowledge that they were insurrectionists? Trump's attorney, they could not. Another state could reach an opposite conclusion. Yeah, that's exactly right. So then what's going to happen? It's a complete mess. So again, even Kagan getting in on this question. The question that you confront is why a single state should get to decide who is going to be the president of the United States. Yeah, like you're going to lose that one. You know that, guys. Supreme Court sends a message to America. In America, the people decide who's president, not lefty judges. J.D. Vance was in the hearing today. Liberals, save some tears for 6 o'clock tonight. Here are the final words from Trump's attorney, who did a great job, Jonathan Mitchell, the attorney for Donald Trump in this case, with his closing argument. Have a listen.
There's no way to escape the conclusion that if this court rejects Griffin's case and also agrees with Mr. Murray's construction of Section 3, that every executive action taken by the Trump administration during its last 2 weeks in office is vulnerable to attack under the APA, and further, that if President Trump is reelected and sworn in as the next president, that any executive action that he takes could be attacked in federal court by anyone who continues to believe that President Trump is barred from office under Section 3. I'm happy to answer any other questions that the court may have.
Thank you, counsel.
Thank you.
The case is submitted.
The Honorable Court is now adjourned until Friday, the 16th of February at 10 o'clock.
Donald Trump himself was allowed to speak on this issue at Mar-a-Lago. Isn't it nice? Just let Donald Trump speak. Donald Trump saying, can you take the person that's leading everywhere and say, hey, we're not going to let you run? I'm going to leave it up to the Supreme Court. Amazing. Amazing. And, by the way, like a reminder for everyone here, and we cannot play this clip enough, this was what Donald Trump posted in the midst of January 6th, whatever you want to call it. We call it a rally that got out of hand and devolved into some people rioting, but most people just wandering around peacefully, because that's what our movement does. Donald Trump posted this video. Twitter took it down within 5 minutes. They didn't want you to hear the truth. This, ladies and gentlemen, is the truth. And we'll hear from the Supreme Court the truth soon. We look forward to it. Have a listen.
I know you're hurt. We had an election that was stolen from us. It was a landslide election, and everyone knows it, especially the other side. But you have to go home now. We have to have peace. We have to have law and order. We have to respect our great people in law and order. We don't want anybody hurt. It's a very tough period of time. There's never been a time like this where such a thing happened, where they could take it away from all of us, from me, from you, from our country. This was a fraudulent election, but we can't play into the hands of these people. We have to have peace. So go home. We love you. You're very special. You've seen what happens. You see the way others are treated that are so bad and so evil. I know how you feel. But go home and go home in peace.